Hi guys, Assalamualaikum and happy holiday to all my followers and audience. I hope you guys are fine and doing great. Again, as the representative of my law firm and associates, I was asked to give some legal consultation on the making of business contracts. So today, I will explain it to you briefly on things that you need while making contracts. First of all, we start with a bit of background on Sale of Good Act 1957. In short, SOGA. It was an Act number 382 in Malaysian Constitution, enacted in 1957, and the statute was applicable to sale of goods in Peninsular Malaysia, excluding the states of Penang and Malacca. The Act was later revised in 1990, and it includes both states. The states of Sabah and Sarawak are not governed by this Act. Instead, they are governed by Section 5 in bracket 2 of the Civil Law Act of 1956. Okay, the first thing that you need to know before you make the contract, especially for businesses, according to Section 4 of SOGA, a contract of sale of goods is a contract whereby the seller transfer or agrees to transfer the property and goods to the buyer for a price. Section 4 also states that the contract of sale may be absolute or conditional, whereby an absolute contract entails a seller transferring property and goods to the buyer, and the contract is known as a sale. Whereas in a conditional contract of sale, the seller consents to transfer the property and goods to the buyer for a price pending the fulfillment of certain conditions, and according to Section 4 of SOGA, the contract is known as an agreement to sell. And next, the second thing is that you need to insert into your contract is the term of a contract of sale of goods, which are based on Section 12 of the SOGA and can be split into two parts, namely condition and warranty. Conditions is the fundamental term of the contract, and the breach of the condition gives the injured party the right to reject the contract. Warranty refers to stipulation collateral to the main purpose of the contract, the breach of which gives the injured party the right to claim the damages but not to reject the goods and treat the contract as repudiated. And the third things that you need to insert into your contract, which I think is the most important ones here, is the statutory of implied terms, where the main function is to protect the rights to every buyer or consumer. These statutory implied terms are in Section 14 and 17 of the Sales of Goods Act 1957 and are the implied terms in every contract of sale of goods. For example, the current issues of today's that involving the whole wide world is when the world was hit by the new pandemic called coronavirus COVID-19. So what affects us more immediately as businesses and individuals are the legal ramifications of the pandemic on our contract, and specifically the performance of these contracts. The basic contractual principles that apply here are the overarching legal concepts of what I mean here is there are two examples of implied terms, mainly the force majeure and frustration. The force majeure is a concept in contract law that describes a clause included in many contracts that frees the parties to the contract from their contractual obligations in the event of highly unusual and unforeseen circumstances like COVID-19. The doctrine of frustration has similar effects to a force majeure clause in that it relieves a party from contractual obligations if an intervening event has disrupted continued performance of the contract. But previous case law shows that the frustration principle is justifiably applied sparingly, such that a contract is not frustrated just because it becomes more difficult to perform. So now let us plan for the future together. Personally, for my own personal view, I prefer contractual drafting to really consider in detail contemplated possibilities of force majeure events and cover the same with specificity and clarity. Today, the whole wide world collectively face the COVID-19, but we don't know what will happen tomorrow, the next year, the next 2 years, the next 10 years. Better still to include in the contracts alternative methods of delivery, performance, and payment schedules in case of such an event. Clarity of terms, provision of options, showing adaptability, statements of possible solutions, all kind of support, preventive contractual cures, and support continuing relationships and modified delivery. Okay, remember guys, there are three important things that you need to insert into your contracts. I hope these videos or this information can really help you to make your business deals in a correct track and really and you can really apply the laws accurately into the contract. Thank you.